Hello and welcome to another edition of MHQ's Foundation 101 podcast, where by popular demand, we are joined again by Kat Zagati. Kat, good morning.
Good morning, Jan.
And today we are tackling something very practical, which is delegation power within and around foundation. So let's jump into the topic right away. I'm interested to know who is allowed to delegate powers within a foundation.
Yeah. So basically, everybody's allowed to delegate powers in a foundation. For instance, the founder, if he holds reserved powers, and also if he wants someone else to state his wishes, the council members, the guardian, and even the beneficiaries, again, if they have certain powers, despite this not being very common in a foundation. However, there is one exception that I should stress here. In a DGM and RAC ICC foundations, the guardian is only allowed to delegate powers if the guardian is a legal entity, and this legal entity is delegating powers to its own legal representatives. In other words, the appointment of the guardian in an EDGM and in a RAC ICC foundation is personal to the guardian and cannot be delegated or assigned to a third party.
But that is possible in the IFC. So if ADGM and RAC ICC regulators are listening, pay attention. This is a difference, and it really matters in practice, as we have seen for several clients. Very topical. So how can I delegate my power, irrespective of my position, that is conferred to me in a foundation?
Yeah. So there are many ways to formally document the delegation of powers. It may happen for two different purposes. Internally, to handle the internal affairs and decision-making within the foundation, and externally, to deal with third parties, with authorities, and etc. on behalf of the foundation.
Okay, and if I pick, let's say, the easiest one first, which would be to delegate the power to deal with external affair, how does that work?
All right, so I will start with the most basic one. Delegation of powers documented through the foundation's constitutive documents, the charter, the bylaws, and the letter of wishes. This means that the delegation of powers will happen at the moment in which the foundation is being incorporated. Let me give you a very common example. When we incorporate foundations, we usually suggest our clients from the onset to delegate the powers of the council members to an authorized signatory who may or may not be one of the council members.
Yeah.
This will help the council members not having to sign jointly on every single document on behalf of the foundation vis-a-vis third parties, and also facilitates the day-to-day administration and management of the foundation on the ground in case the council members are not in the UAE.
Understood.
Now you're going to ask me, but what if the members of the foundation wish to delegate powers after the foundation is incorporated, isn't it?
Exactly.
So this is also perfectly possible, provided, of course, that the right documents are put in place. So I'm going to give you another example. The foundation has been incorporated and the council members now wish to delegate powers to a legal representative to handle the acquisition of a property, right? In this case, first of all, we must check whether the council members have these powers to be delegated, right? Obviously, because no one is supposed to delegate powers if the council members in this case have not been previously conferred the powers.
Yep.
So assuming that the council members have the powers to acquire the properties on behalf of the foundation, then they must issue a council members resolution identifying this legal representative and delegating the specific powers they wish to delegate. This resolution can be attested by the foundation's register, being it the IFC, ADGM, or RAC ICC, or the council members may opt also to notarize a power of attorney with the notary public if they want. That's also a possibility.
That is, if you find a pragmatic notary public, which we have now identified, which all is good there. Great. So now, what about delegating powers to deal with the internal affairs of the foundation? How does that work?
Yeah, can I come back to this a little later, because there is one example that I haven't gone through and it's very important.
Okay, yeah, sure.
It's still about the delegating powers externally. Yeah, so which is another typical example that we usually work here. So when the foundation wishes to delegate powers to third party in charge of overseeing and managing an investment account, which is owned by the foundation, right? So these also may be triggered by the founder providing guidelines to the council member via a letter of wishes. And again, the founder in this case having reserved powers to manage the foundation affairs. Other than that, he wouldn't be providing the guidelines in this case. Then upon receiving this letter of wishes, the council members would then deliberate and accept the founder's suggestion via a council member's minutes of meetings. And lastly, the council members delegating the powers to the investment account manager via council members resolution or a power of attorney, depending on the requirements of the bank. So that's also very typical.
And maybe an example from me here is that often we had just had the cases of two professionals from the financial industry who are perfectly capable of managing assets across multiple custodians, but their fear was that in the event they were not here, their wives, say, would be unable to do so. So they preliminarily appointed an independent asset management firm to be at their side, and in the event of their demise or their inability to act, they were already appointed to do so towards third parties. So very topical example in the real world, this one. So let's look at the internal affair now. How does that work?
Right, yeah. So this can be put in place when the foundation members wish to delegate powers related to the decision-making process within the foundation. I'm going to give you other examples to be easier to understand. So let's start with the founder. If the founder has reserved powers to change beneficiaries in a foundation and he wishes someone else to action these specific powers, he can then delegate these powers to a third party, and then this third party will then be empowered to change the beneficiaries of the foundation on behalf of the founder. Now, talking about the guardian, for instance, so the guardian has the specific powers to veto the council member's decision in respect to the distribution of assets to the beneficiaries, and the guardian wishes to delegate these powers. Then his delegate or his attorney will be empowered to veto the council member's decision on behalf of the guardian. Again, when I'm talking about delegation of powers from the guardian, I'm talking about a DIFC foundation, not an ADGM or a RAC ICC foundation, right? Then also the council members, if they want to delegate powers in relation to the substitution of guardian, for instance, these powers can also be delegated to a third party. So see, these are typical examples of delegation of powers to deal with the internal affairs of the foundation. Change of beneficiaries, distribution of foundation assets, substitution of the guardian. The bottom line is, to the extent that the members of the foundation delegating the powers having previously granted these powers, and to the extent that the delegation of powers is allowed as far as the foundation documents and the foundation regulations are concerned, then the members of the foundation will be able to delegate powers to third parties.
Okay, clear. So reasonably easy to check if that works, because you just check the bylaws and the minutes of meeting and you have your answer. Now, how do you document the delegation of powers to deal with internal affairs of the foundation? Is it the same way as delegating towards third parties and external? How does that work?
Yeah, same mechanism, depending on who will be delegating the powers. So if the founder is delegating his powers, this must be documented via a letter of wishes issued by the founder, which will then be ratified by the council members via a minutes of meetings. If the council members are the ones delegating the powers, then minutes of meetings will be enough. In case the guardian is delegating powers, then this must be documented via a declaration signed by the guardian, and then this declaration will have to be ratified by the council members, again, via a minutes of meetings. As you could see here, considering that the delegation of powers is internal, we will not need to produce a power of attorney or a resolution attested by any authority or the notary public.
All right, very clear. So thank you for this overview of delegation in and around a foundation as far as powers. Clearly, you've deserved your newly minted TEP title, Cass, so thank you for that.
Thank you very much.
And for anyone that would have additional question on this specific topic, foundation in practice in general, feel free, reach out, let us know what you think. And if you have some topics that you want us to cover going forward, also drop us an email. We'll be very happy to deep dive into this. The idea is to make it as educational as possible. Kat Zagati, thank you very much. Have a great day ahead. Bye-bye.
Pleasure. Thank you.